dans cette phase de reconstitution que nous vivons maintenant en Tunisie. Pour cette raison, nous avons parmi nous des experts qui vont nous parler d'autres expériences. Nous allons commencer tout d'abord par passer la parole à Madame Ivana Nasti, je m'excuse. Non, voilà.
Mais je crois que je suis la seconde.
Madame Virginia Rodriguez.
Ok.
Ivana, vous êtes la première, madame, inscrite.
Merci.
Donc, à vous la parole.
Merci beaucoup. Oui, je suis Ivana Nasti de l'autorité italienne de régulation. Oui. Et je vous parlerai du cadre européen sur les communications électroniques, mais pas en général, naturellement. Je vous parlerai en particulier du pouvoir de sanction dont le législateur européen a doté les autorités, les États membres et par conséquent les autorités nationales de régulation. Donc d'abord, le cadre européen est vraiment très clair dans la considération du pouvoir de sanction comme un pouvoir clé pour le correct fonctionnement du système de régulation dans le milieu des communications électroniques. Le législateur européen a fourni aux autorités nationales de réglementation l'autorité, les pouvoirs et les outils pour assurer que l'exécution des décisions soit tout à fait cohérente avec les mécanismes de participation, les procédures, je me réfère aux procédures de consultation publique, si bien qu'au droit d'accès, qu'ils soient cohérents avec les remèdes régulatoires et avec les systèmes nationaux judiciaires. Donc le cadre européen a fixé les principes en laissant en même temps au législateur national le pouvoir de déterminer dans son pouvoir discrétionnaire d'individuation et de quantification des sanctions la façon à travers laquelle les autorités nationales de réglementation doivent appliquer ces pouvoirs pour assurer, comme j'ai à peine dit, pour assurer un système tout à fait complet et cohérent et efficace dans le domaine des communications électroniques. Nous n'avons pas trop de règles. Je voudrais me concentrer sur deux articles en particulier, même parce que je sais que vous bien connaissez les règles générales, le droit d'accès qui est prévu dans la carte fondamentale de l'Union européenne sur les droits à une bonne administration. Je sais que vous connaissez très bien les mécanismes de consultation publique qui ont prévu dans l'article 7 de la directive cadre. Et donc, nous parlons de l'article 10 de la directive autorisation. Bon, ce n'est pas la directive cadre, mais c'est très important pour nous parce que cet article fixe la procédure de sanction. Pas avec trop de mots, mais avec des mots simples et très clairs. L'article 10 de la directive autorisation, la numéro 20 de 2002, déclare que lorsque l'autorité constate, donc il y a la première phase de constatation de l'infraction, il notifiera l'entreprise de ses découvertes et donnera à l'entreprise même l'opportunité, dans un délai de temps raisonnable, nous dit la directive, l'opportunité d'exposer ses opinions et de remédier à l'infraction même. Si l'entreprise concernée ne remédie pas aux infractions contestées dans la période fixée par l'autorité de réglementation et auparavant par le législateur national dans la loi générale, l'autorité compétente peut prendre des mesures appropriées. Donc la caractéristique des mesures pour assurer le renforcement des décisions de l'autorité doit être à conformité à l'ordre général et au système de règles qui a été préfixé. Et à cet égard, les États membres, donc les législateurs nationaux, autorisent l'organisme public que, pour ce qui nous concerne, c'est l'autorité nationale de réglementation, à imposer des pénalités financières quand c'est nécessaire. C'est tout là. Donc, il n'y a pas la déclaration d'une procédure très stricte, ou trop détaillée. Mais c'est important. Nous avons des éléments fixes que nous devons respecter. D'abord, nous devons avoir une procédure. Cette procédure doit se caractériser par le respect du principe de légalité. On doit notifier l'infraction, mais l'infraction, la conduite punible, doit être connue par les opérateurs auparavant, d'abord, avant que l'infraction même peut être punie. Et naturellement, le principe de légalité doit être assuré aussi dans la prédétermination a priori des sanctions et de la quantification des sanctions même. Même en laissant à la discrétionnalité de l'autorité nationale de réglementation la quantification en concret par rapport au cas concret. En effet, l'article 10 déclare que les mesures doivent être appropriées et proportionnées. Et l'article 21 bis de la directive cadre, comme il a été modifié et introduit dans 2009 avec la directive 140, nous indique aussi que les pénalités prévues, donc avant que la conduite soit commise, doivent être appropriées, efficaces, proportionnées et dissuasives. Donc, ces mots-clés, ce sont des mots que nous sommes obligés à tenir en compte, je crois, dans un processus de révision de l'article 74. Donc on peut réfléchir beaucoup et en discuter. Appropriée, efficace, proportionnée, dissuasive par rapport, je dirais, au type, à la gravité, à la disvaleur de l'infraction, à sa diffusion sur le territoire national et même au bien offensé. Donc, je crois que ce sont des principes tout à fait simples, mais qui on doit appliquer en tenant compte de la réalité et du contexte concret dans lequel nous agissons. Et la règle qui complète le système et qui est fixée dans l'article 10 de la directive autorisation que j'ai déjà mentionnée, nous impose de prévoir un mécanisme d'appel de recours qui soit efficace contre les mesures de sanctions prises par l'autorité. L'article 4 de la directive cadre, nous le connaissons, et c'est très clair en déclarant que les États membres assurent des mécanismes efficaces au niveau national pour que l'utilisation ou l'entreprise affectée par une décision de l'autorité a le droit de faire appel contre la décision même devant un organisme d'appel qui n'est pas nécessairement un juge. En Italie, c'est un juge, mais il n'est pas nécessairement un juge. La directive nous parle d'organisme d'appel qui doit être indépendant des parties impliquées, qui peut être la Cour et qui devrait avoir l'expertise nécessaire et appropriée pour juger la façon à travers laquelle l'autorité a exercé son pouvoir et sa discrétionnalité dans l'activité de fixer les sanctions. Les États membres doivent assurer que les mérites de l'affaire est pris en compte aussi et qu'il y a un mécanisme d'appel efficace par rapport à la décision judiciaire de premier degré. Et enfin, un autre élément très important, c'est que la décision de l'organisme de régulation nationale doit être maintenue en attendant le résultat de tel appel, à moins que l'organisme d'appel même décide autrement. Donc, c'est un principe particulièrement relevant pour nous, pour l'activité de l'autorité, parce qu'il évite le risque d'avoir des appels qui sont strictement instrumentels à suspendre l'efficacité des décisions. Merci, j'ai fini.
Merci Madame Ivana. Donc c'est très bref mais c'est très consistant. Le cadre communautaire ne peut pas donc entrer dans les détails qui sont laissés aux États parties, mais l'essentiel donc a été donc dit. Je retiens plus particulièrement donc le respect du principe de l'égalité. Mais nous avons discuté ça lentement dans le collège de l'INT à l'époque. Est-ce que le respect de ce principe peut donner aussi, peut-être peut s'étaler pour donner au régulateur lui-même la possibilité de décréter quelque chose sur une décision, de prendre des décisions d'ordre général sur les sanctions, sur la manière d'appliquer ces sanctions, ou c'est l'autorité législative qui doit le faire. Donc la question doit être, la réponse à cette question doit être faite à la lumière des principes généraux de droit de la Constitution tunisienne. Est-ce que la matière de sanctions en général administratives peut être réglementée par les autorités de régulation ou par les autorités gouvernementales ou par le législateur? Tout cela donc doit être bien défini dans notre œuvre. Alors de l'expérience européenne, nous passons donc à l'expérience américaine. Monsieur Kelly Cameron, donc il est donc toujours avec nous donc depuis maintenant 2 ans ou 3 ans, et donc il va nous éclairer sur cette expérience. Voilà, merci.
Merci beaucoup. Je m'appelle Kelly Cameron. I will switch to English, which will be much better for everyone. I worked for many years at the U.S. Federal Communications Commission, and now I'm a lawyer in private practice, and one of my clients is the U.S. Agency for International Development, which hired me in 2012, actually, to make recommendations to the government of Tunisia about whether to amend or replace the Telecom Code of 2001 in order to make it consistent with international best practice standards. And my recommendation is to replace it, and we've been working with the ministry and with INT on a new digital communications code. And the main purposes of the digital code are to create an effective, truly independent regulator that will, I hope, be a converged regulator, meaning that it will have responsibility for telecommunications and broadcasting, will have authority to manage the spectrum, and will have the full range of powers that telecom regulators typically have, which, among other things, includes enforcement powers or sanction powers. Let's see. Before delving into details about how the FCC does this, I wanted to step back and talk about why we need an enforcement regime. And as Mohsen Jaziri said earlier, a regulator without sanctions authority is meaningless. You can't really regulate if you can't enforce the rules that you've adopted. But what rules do you want to adopt, and why do you want to enforce them? Well, in my view, in a competitive market, the first line of defense, essentially, for consumers is competition. We believe that competition will produce lower prices, greater choice, more technical innovation. But at the same time, it's also true that companies may sometimes do things that will harm the interests of consumers. And that, in my view, is what the regulator should be focused on. Is a telecom operator doing something that harms consumers? Now, in addition to that, there's sort of some broader cases where sanctions are appropriate. For example, if somebody is operating a radio transmitter without a license, that may not have direct effect on consumers, but it nevertheless is a serious violation of the law, both in the United States and in pretty much any other country I can think of. And there need to be remedies for that. So enforcement or sanctions is a key tool for an effective regulator, and mainly to protect consumers from unfair practices. Now, it's interesting, the discussion that we had this morning about the difference in the Arabic and the French versions of the telecom code between infringement and unfair practices. I don't want to really get into that now, but again, I think that most enforcement should focus on conduct that harms consumers. And one reason that sanctions are important is because I think essentially what Mohsen said implies this. If you have this tool, if you have the ability to impose sanctions as a credible threat, that will help to encourage operators to follow the law and not to engage in anti-competitive conduct. It's just like having speed limits and having enforcement. Obviously, the process has to be fair to all parties, consumers and service providers, and the enforcement process has to be transparent and accountable. And in this, as in so many other instances, I think that while we use different words sometimes, there's really not much difference in substance between the U.S. approach and the European approach. Their magic words, so to speak, are proportionality and so on, and those are important principles. We talk about transparency and accountability, but ultimately the ideas are pretty much the same. So the FCC is the U.S. regulator of telecommunications and broadcasting. It was established in 1934. It has plenary jurisdiction for regulation of interstate and international telecom and all broadcasting. The FCC shares jurisdiction with the state regulators for intrastate telecommunications, but that's not an important issue for today. And the FCC also has exclusive authority to license and regulate the use of the electromagnetic spectrum. So that also means that the FCC has exclusive authority to enforce rules and impose sanctions in all of these areas. Again, an issue that came up this morning that I want to touch on briefly. In the U.S. context, we also, of course, have the distinction between administrative procedures and criminal procedures. The Communications Act actually establishes both. Section 501 of the Act and 502 of the Act deal with criminal violations of the Communications Act, which can lead to monetary fines or even imprisonment. Now, I've been working in this area for over 30 years, and I can't think of a time, I'm not aware of any instance in which anyone has been sent to prison for violating the Communications Act. But it's there, and you know, I would think if it would ever be used, it would be used for example, someone operating without a license. Potentially would be an issue that could be criminally enforced. That, of course, would be, the prosecution would be handled by the U.S. Department of Justice through the federal courts. And, you know, my presentation says it's very rare. It's so rare that I'm not sure it's ever been done. The main tool that exists in the Communications Act for enforcing the Act and the rules and the terms of licenses is that the FCC has authority to impose monetary fines, or forfeitures, we call them. A forfeiture is a civil penalty. So again, the FCC is not going to send anyone to prison. The FCC, as I mentioned, has broad jurisdiction, and it adopts rules in a wide area of substantive fields: interconnection, licensing, competition, technical regulations, network neutrality was a recent rulemaking, broadcasting, of course, also. And the regulations are adopted pursuant to a transparent public consultation process, which again is the standard in virtually every country. In the U.S., the FCC operates under a law called the Administrative Procedure Act, which governs all regulatory agencies. And that means that the FCC has to issue a notice of proposed rulemaking that explains what they're considering doing, then allows interested parties an opportunity to file comments and reply comments, and then the Commission adopts a report and order announcing its decision and explaining its reasoning. So an example that I'm going to talk about for a few minutes today involves two practices that the FCC has prohibited, and we call them slamming and cramming, which probably don't translate very well into French or Arabic for that matter. Slamming involves the unauthorized change in a consumer's long-distance carrier. And this used to be a really big deal when we had a clear distinction between local telephone service and long-distance service. We still have a lot of long-distance carriers, and some of them, many of them, engage in this practice of changing consumers from, say, AT&T to carrier X without actually getting the consumer's approval. And the FCC has adopted clear rules that say exactly how this marketing process has to work, and you have to get clear consent from the consumer before changing their carrier, and then that has to be verified by an independent third party. And despite all of these regulatory protections, it happens fairly frequently still that consumers are slammed. Their carrier is changed without their consent. Cramming involves a carrier adding services to a consumer's bill that they did not request. And again, the FCC adopted rules through its regular rulemaking process prohibiting both slamming and cramming. The FCC can investigate matters on its own if it becomes aware of something that it thinks might be a violation of the Communications Act or of its rules. But most often, FCC enforcement actions begin with a formal complaint submitted by a consumer. So the FCC investigates these complaints when they come in. That involves also sending a letter of inquiry to the company that is alleged to have violated the act or the rules. The company then sends back their response, and based on its review of all the facts that have been presented, the FCC can then issue what's called a notice of apparent liability to forfeiture, which means that the Commission has found that it looks like this company did something unlawful, and here's how much we propose to fine you. The company can then appeal the notice of apparent liability, which they almost always do, and the FCC will then make a final decision based on comments from the company and anyone else who wants to participate. So here's an example of a recent FCC decision on both slamming and cramming, and it involved a company called US Telecom Long Distance Incorporated, which is a small long-distance carrier that employed a lot of people to call consumers and try to get them to change their long-distance service. The FCC received more than 60 slamming and cramming complaints from consumers, and as with many other things, if you've gotten 60 complaints, the odds are very high that there have been a lot more people who have been victimized by this practice as well, but either don't know it or may not know that they have the right to complain to the FCC, or may have managed to change their carrier back and therefore don't bother filing a complaint. So the FCC sent a letter of inquiry to USTLD in May of 2013, and then in January 2014, they issued a notice of apparent liability, finding that they had violated the Act and the FCC's rules, and proposed a forfeiture of $5,230,000, which obviously is quite a lot of money. USTLD filed a response to the notice of apparent liability, and first it said, "Oh no, we didn't violate the rules. We didn't engage in slamming and cramming. We got approval from consumers before changing them." And then, even if they did break the rules, they wanted the FCC to reduce their fines. The FCC had a lot of information from consumers that, in their view, made it clear that this company had violated the rules. They did, however, reduce the forfeiture from $5,230,000 to $4,480,000, and this issue was released just a few weeks ago on September 15th. I should note that on the same day, the Commission issued orders against two other companies that were owned by the same people for another $6 million total. So this pretty clearly was a large-scale operation to essentially defraud consumers. Now, USTLD can appeal to the Court of Appeals, which they probably will do, and they have 30 days from the release of the order to file an appeal, and we'll see what happens from there. Forfeitures are the most common sanction that the FCC imposes, and frankly, slamming and cramming are the top enforcement areas because this has been a really common practice that has affected a lot of consumers. In other contexts, the FCC can impose other remedies as well. For example, if the Commission finds that a company has overcharged consumers, even for services that they've legitimately ordered, it can require the company to submit a refund to consumers. And in extreme cases, the FCC also has the power to suspend or revoke licenses. This obviously is the ultimate sanction, and it's used very rarely. I describe it as the death penalty, because obviously once the Commission revokes a license, you're out of business. And in fact, I can only think of one time when the Commission revoked a company's licenses, and that was in about 1984. And obviously, once the Commission revoked their licenses, it was a company that provided paging services. That company went out of business. So that is the death penalty. Now, I should mention with USTLD, they argued, among other things, to the FCC that they couldn't afford to pay these forfeitures. Whether that's true or not, I don't know. But it wouldn't surprise me if a fine of almost $4.5 million would be enough to put them out of business. So clearly, this is a very powerful tool that the Commission has, and should therefore be exercised with a degree of caution. At the same time, sort of reading between the lines of this decision, it seems clear that most of this company's business is really just a fraud. I mean, they do provide service once they unlawfully change people to their network, but that's their business model, is essentially breaking the rules to get customers. So in that context, maybe it is appropriate to impose a sanction that effectively puts the carrier out of business. Again, we always talk about transparency and accountability, and this also reminds me of one of the topics that was discussed this morning, which is clarity in the law and the precision of the terms used in the law, which is one of the things that I think really could be improved in the telecom code or in the new digital code that we're working on, which is to make sure that it's very clear who has particular responsibilities and how they're supposed to exercise them. I think it's important that the law state very clearly also what the procedure is, that it has to be, that actions have to be taken pursuant to transparent procedures. The offenses that a company might be charged with also have to be very clearly defined, either in the law or in regulations adopted by the regulator. And when you're enforcing those laws or regulations, you have to state clearly in writing what the service provider is accused of and why it is a violation of the law or the regulations. And obviously, as in the European example and in Tunisian practice, the regulator has to give the service provider an opportunity to respond. The Commission also adopted rules that specify the maximum forfeiture amounts for different types of violations. The maximum forfeiture for slamming is $40,000 per incident, which is the highest, 2 minutes, okay. The highest amount for any particular violation. One feature in the Communications Act that I think is interesting is that each day of a continuing violation counts as a new violation. This isn't so much true with slamming. I mean, once you're slammed, they charge you once. But if, for example, you were operating a transmitter without a license today, that would be one violation. Tomorrow would be another violation. So those fines can accumulate. The rules also give the Commission some discretion and some flexibility to either increase or decrease the forfeitures based on factors such as the nature, extent, and gravity of the violation. So minor offenses obviously would attract a small penalty, and major offenses a much bigger penalty. The one thing that the Commission has always emphasized is that misrepresentation or lack of candor before the Commission is the most serious offense that a company can commit, because it really undermines the foundation of the regulatory process. And so that case I mentioned from 1984, where the Commission revoked over 500 licenses that this one company held, was based on misrepresentation. Again, as I already mentioned, the law has to establish a clear procedure for independent review. In the case of the FCC, this review goes to the U.S. Court of Appeals. And the court typically does not review the facts of a case that comes before it, but reviews whether the Commission's actions are consistent with the law. I think I have like one more slide. Yes. So again, sanctions are an important tool as the market becomes more competitive, and it's important that all market participants obey the law. And the regulator, as Mohsen said, has to have the ability to enforce the law if it's going to be effective. For the regulator, however, deciding what the priorities are for enforcement, I think is a question that needs to be guided by the real purposes of regulation, which I think mainly involve ensuring that a competitive market works to the benefit and not the harm of consumers. So thank you very much for your attention. Thank you for inviting me.
Merci, Monsieur Kelly. Donc, c'est très instructif. Donc, malgré les spécificités de l'expérience américaine, donc sur le plan marché tout d'abord, mais aussi sur le plan tradition juridique, on retrouve les mêmes principes. Ah, ok. Alors voilà. Malgré les spécificités donc, de l'expérience américaine, tant sur le plan marché que sur le plan tradition juridique et système juridique, on retrouve les mêmes principes. Je retiens particulièrement, et c'est une matière à réflexion pour nous, la possibilité du consommateur d'agir devant le régulateur pour demander la sanction, pour demander donc d'agir en responsabilité devant le régulateur, chose qui est permise dans le cas de slamming, et sujet bien compris. Aussi les sanctions. Nous avons l'expérience qui parle de la responsabilité civile. Pourquoi toujours c'est la sanction, c'est l'amende administrative? Il faut aussi penser sur une sanction de type commercial, de type civil aussi. Ça peut être aussi, ça peut fonctionner dans pas mal de cas. Il nous a proposé aussi une solution pour cette infraction continue, le fait de griller le feu chaque jour. Il nous a parlé de donc, découpage par le temps. Chaque jour qui passe, c'est une infraction indépendante. Ça, c'est très intéressant. C'est une matière donc, à approfondir ces réflexions et on peut donc s'inspirer largement de cette expérience pour améliorer et rendre notre action efficace. Je passe maintenant à une autre expérience que c'est donc l'expérience espagnole. Madame Virginia Rodriguez va donc nous présenter cette expérience. À elle la parole, madame.
D'accord. Merci beaucoup pour votre attention et pour l'invitation. Je aussi changerai à l'anglais parce que c'est beaucoup mieux pour tous. We've heard a lot of very interesting issues that I see that repeat in every system, and we have as well some of the problems that you mentioned. I'm going to try to explain a little bit the basis of our system, of the Spanish legal system or framework that is based on the European one. Of course, what we do is we transposed the directives. We have some specificities. I will talk a little bit about the types of. It's fine, like that. Okay, the types of infringements over which we have faculties in Spain. Just a little bit of explanation. The CNMC has certain competences, but in Spain, the Ministry of Industry is as well a national regulatory agency, and it can also sanction certain conducts. So I'm going to focus, of course, on our competences. I will talk a little bit as well about periodic penalties, which is a means of enforcement of decisions that is not sanctioning. It's a little bit it's a means of execution of decisions, which is very important for us in certain cases. Is being used sometimes only, but I think it deserves some attention, and I will explain as well some cases. Well, the first thing we are repeating in the floor, in the table, is that many regulators is that we don't want to sanction. It's not that, our goal is not to sanction operators or providers, that's clear. But it's essential to have a toolkit of enforcement measures, because it's essential to be able to make the laws or regulations to be complied with. It's essential for consumers, as my colleague representing the FCC said, and it's essential for competition, not for competitors, but for competition. We have to ensure as well that there is a level playing field, okay, that some operators comply with the regulations and others not. It's not fair. It's a floor to ensure non-discrimination. In our system, we have mainly the possibility to impose sanctions, or the possibility, these are the periodic penalties I was talking about, the possibility to enforce the compliance of a resolution, which is something that sometimes we've done at the same time that opening a sanctioning procedure. Talking specifically about infringements and sanctions, we have our Telecoms Act from 2014, and of course, as well as in many other legal systems, the administrative laws that apply as a floor, as a common base to all public administrations. And in fact, we have reviewed in Spain these laws very recently. On the 2nd of October, so last week, these two new laws, laws 39 and 40, entered into force. And there are some novelties that I will comment later on. Of course, we have in all civil law systems the general sanctional principles of legality, proportionality, prescription of sanctions. For example, in our case, very serious infringements, we will see it later, prescribe, and after 3 years we cannot pursue, we cannot sanction a conduct. Serious infringements, 2 years, and minor infringement, 1 year. So a minor infringement after 1 year, the administration cannot I'm speaking about telecoms. Other sectors have other rules. No? After those periods, we cannot even open a procedure. Non-retroactive application of laws, of course, and retroactive application of more favorable laws to undertakings, non-bis in idem. These are principles that you, of course, know, and we also incorporate them to our regulations. Speaking about the procedure, we generally start before opening a sanctioning procedure. We carry a preliminary investigation. Almost always, because we don't want to impact the undertaking. I mean, we think that even the opening a sanctioning procedure already causes an impact on the undertakings. So we need to have some sureness. This preliminary investigation can be opened ex officio. I mean, because we have the evidence already. Usually it's because an undertaking or a consumer as well, we also have this possibility, come to the regulator and provides some evidence about the possible infringement. In Spain, there is a very clear separation between investigative versus decision-making phase. That means that our board opens the sanctioning procedure. The whole work carrying out the investigation, looking for the evidence, is made in my department, in the investigation direction, and we afterwards prepare a proposal of the evidence. I mean, of the facts, of the evidence, of the qualification of the conduct, if we think that there is or not an infringement, and even the proposal of the sanction itself. Because I know that many regulators don't do that in the investigation phase. And afterwards, the whole case, the whole file goes to the board and to its team and look for everything, things they think if there is a need for complementary measures or whatever, and enact the decision. So, for example, the proposal of the investigation department cannot be appealed. It's notified, of course, to the undertaking, but it's not a final decision. It's just a proposal in the procedure. We take very seriously, of course, the rights of the accused infringing party. The undertakings have the possibility to get access to the file in any moment of the infringement procedure. They have to know the identity of the case handler in order to check if there is, for example, they think that they want that a specific case handler cannot be objective or whatever. There are certain reasons why it can be recused. And well, but maybe the most important is that they can undertakings can get permanent access to the file. They can come to the commission at any moment, and they have the opportunity to, of course, provide evidence and make allegations or observations twice in the procedure. At the very beginning, when we open the procedure, the sanctioning procedure, and at the end, when the investigation direction makes the proposal to the board, they have a whole month to make allegations. So the rights of defense are quite well preserved. We have some novelties, I was saying, in recent administrative laws that I find interesting, but I don't know which success they will have in Spain. Because these novelties, which is the possibility of exonerating the undertaking from paying the fine, come clearly from the leniency programs of competition. In competition, there are some program. There is this program in March in place in Europe since many years ago, and is very successful to avoid cartels, which is a very specific competition infringement or problem. But in administrative infringements, usually the undertaking that is committing this possibly an infringement is one. There's not so many cases where there are 2 or 3. Why I am saying this? Because what the new law establishes is that the reporting party to the evidence to the regulator must be exonerated from paying the fine if there are certain characteristics that are there. One, that there are more infringing parties. So the conduct is carried over by several undertakings, for example. Second, if it's the company, the person, legal or natural person, that brings the evidence to the administration, so that the administration couldn't open a procedure by itself. If we didn't have the evidence, if this party comes to us and brings the evidence, that's another case. And of course, if the damage is ceased, is repaired, and the conduct is ceased. So if the undertaking carries over a good conduct. In that case, the law says that the undertaking must be exonerated from the fine. But as I said, this entered into force on October the 2nd, and we don't have any practice still with this. And I haven't seen a case in my experience where well, maybe it was possible, but there are not so many infringement conducts that are carried over by 2 or 3 companies at the same time. In competition, yes, but for example, violating a decision, but it's more difficult. Also, the law establishes that the accused party will get a reduction of the fine in at least 20% if it recognizes the responsibility. This is new as well. Until now, recognition of responsibility, for example, is a criteria to diminish the sanction. I will show you now the criteria that we have in our laws, but it wasn't established which quantity, in which proportion. I already talked to you about the procedure. I think we can pass to another subject. Types of offenses or infringements. These are, we were talking about the principle of legality, which the need that we have, that our laws specify, of course, the offenses that can be punished. This is an essential principle. Of course, companies need to know for which conduct will be sanctioned. These are the types of infringements that we have in the law, in order that you see as well how we implement this principle of legality. Very serious infringements, failure to comply with a CNMC decision, that's a very serious infringement. Afterwards, we will have to see if the decision is clear, of course, which behavior demand the decision and why there is an infringement. But this is made by the regulator. The law what says is the failure to comply with a CNMC decision is a very serious infringement. Some of them are, I mention it because they are important. The failure to comply with requirements demanded by the regulator, or the failure or the refusing to be inspected, or obstructing an inspection is a serious infringement. This is relevant because the regulator needs collaboration. I mean, we never, to be honest, we never sanctioned an obstruction of an inspection. We haven't had problems like that in Spain. We have sanctioned many times the non-providing of information. We have a very important toolkit of powers to request information to operators for statistical purposes or to carry over market analysis. And in some cases, few cases, we have sanctioned that conduct. It's as well a very serious infringement, the very serious contravention. There is discretionality there. It's the regulator who has to say if it's a very serious infringement, contravention, or is just serious. Of obligations regarding access, interconnection, and service interoperability, which are specified in the law, of course. and as well the contravention of characteristics and conditions established for number retention, the infringement of the regulations on portability, the certain conducts that impede or harm portability in the procedures regulated by us is a very serious infringement. In the chapter of serious infringement, for example, we have one that we use a lot as well, and it's not, I'm not glad for it, but I tell you the data. No? The failure to comply with the conditions linked to the allocation and granting of usage rights of numbering resources, not using well the numbering resources. That's also quite common. Or just not notifying to the CNMC the start of providing services. Well, this is like the classification, just for you to know how we have the principle of legality in our telecoms law. And the sanctions would range in this, in the amounts that we have in the slide. If a very serious infringement, if it's a very serious infringement, we can impose a sanction at least equal to the gross profit. It can never be below, because it couldn't be deterrent. I mean, it has to be dissuasive. It doesn't make any sense that if you can quantify the benefit, you impose a sanction that is below. But it can go until 5 times the gross benefit obtained in the commission of the infringement. 5 times. I have to say that for us it's many times difficult to calculate. Okay, to calculate the benefits. It's difficult, in fact, because it's the profit linked to the conduct. Okay, infringing, not the gross. Before we had another system where we can fix the sanction according to the gross profit obtained in the branch of the activity affected, but now we have all the benefit obtained due to the conduct, infringing conduct, or if we cannot determine that benefit, we go to 20 million euro as a maximum limit. Okay, and then we have to do our work. For serious infringement, it could be twice the gross benefit or 2 million euro, and for minor infringements, the limit would go until 50,000 euro. And there are possible ancillary sanctions as well for very serious and serious infringements, not for minor, like the suspension of services or the withdrawal of rights of use. Those are qualified as ancillary sanctions in our system, although we have these orders to cease conducts that are not ancillary sanctions that I'm going to talk about just a minute because we don't have more time. We also have established what are the criteria for the establishment of sanctions. I'm going to jump off slide because we don't have time. We can see it later. And just a minute, no? You were talking before about the orders to cease conduct. We have, our legal system has these ancillary sanctions, no? To, for example, withdrawal of rights or taking out, revoking the license. We have never imposed that sanction, for example. But apart from that, there is this legal basis that my Italian colleague was talking about before, the Article 10 Authorization Directive, that allows, if implemented in your internal law, as we have allow regulators to just order a cease of conduct if it can harm competition. And I want just to explain how we use it. We use it in very rare cases, in fact, because it has a clear impact on consumers, and we use it on the framework of ex-ante regulation. If we have imposed to the SMP operator, for example, a very clear obligation of technical replicability or economic replicability, and they have to amend a reference offer, for example, okay, to ensure the provision of a service before putting into the market a retail offer, We are talking about an SMP operator that is integrated, vertically integrated, provides services and minor and retail services. If they notify us an offer, a retail offer that doesn't comply with this economic replicability test, and they have to notify us all their offers, no? we can stop that offer, okay? But we do it in this context, okay? Because of these powers. I don't have a lot of time. I will just jump over the example that I wanted to put, just not to take more time from Vincenzo. For example, in 2003 and 4, we have this case in which we impose at the same time periodic fines and a sanction. I was just took this case because it's quite important, not for the sanction but for the meaning. As per the directive of 2000 and the amendment of the directive in 2009, the Universal Service Directive, regulators have to ensure portability of fixed and mobile numbers in one working day. You remember this provision, for sure, that is in the slide. We enacted a decision in April 26, 2012, establishing the moment in which this one-day portability would be already effective, and after a long procedure with operators, we fixed the date for July the 1st, 2013, so 14 months later. In the process, 3 months before this date, Orange requested an extension until November 2013. So 3 months before the date that were to be, the important date to have this one-day portability implemented, this company couldn't have its system prepared, technically prepared, and asked for an extension. It was too late. We rejected that right of that extension because this was very complicated. It is very important to understand that from a technical standpoint, the compliance of these technical specifications had to be ensured by all operators at the same time because the system have to interact together. And so we denied that recession and we opened both of the procedures. Towards a decision in June 2013, we reminded Orange their duty to comply with portability in one day. The periodic fines procedure, I'm sorry, I'm going too fast, is a procedure that requests a warning before. We have to warn the undertaking that if they don't comply, for example, in 10 days, the periodic fines will be start over, and we have to fix the criteria of the periodic fines. In this case, we warned of an application of daily coercive fines of €8,000. Afterwards, there was an appeal, and it was €6,000 per day, we talk. And these fines were in place, we liquidated these fines until the moment the decision was complied by Orange. This is a mean to ensure compliance. It's not a sanction, it's not a punishment, it's a try to make the company to comply. Then this was a very important issue for us at that moment because we wanted the portability in one day to be effective by the whole sector. At the same time, in parallel, an infringement procedure, for example, was opened, and that finished in July 2014 with the declaration of a very serious infringement and certain criteria taken into account as an aggravating criteria, the nature of the damage caused to consumers, to the general interest, and to the other operators that were prepared for this, at this date, to make this happen, the portability in one day. On the other side, as an attenuating criteria, so to diminish the sanction, we took into account the lack of profit obtained by Orange by this conduct. They didn't get any profit, more the opposite way around. And at the end, the fine was 500,000. And well, that's it. I think that I leave it here if you have any question.
Merci, Madame Rodriguez. C'était très intéressant. le temps ne nous a pas permis de s'étaler, mais j'espère que vous pouvez échanger avec le personnel de l'INT afin de pouvoir donc creuser et voir votre expérience de près. Surtout la partie procédurale, vous avez utilisé des vocables comme cartel, exonéré, enquête préliminaire, accusé, reconnaissance de culpabilité. J'ai l'impression que je suis avec un procureur. Donc voilà, ce sont des termes qui me sont très familiers en tant que vice-procureur maintenant. Et qui cadre bien avec votre introduction que le pouvoir de sanction du régulateur doit se reposer sur un cadre juridique plus large qui lui sert de référence. La référence, maintenant, je crois que c'est le droit pénal, votre droit pénal, mais fallait-il rejoindre aussi, monsieur, donc la remarque de monsieur Mohsen, il faut habiliter juridiquement, ce n'est pas techniquement, mais il faut habiliter juridiquement le personnel de l'INT pour faire les enquêtes préliminaires, qui sont des procédures qui mènent à une sanction, qui doivent donc être légalisées. Mais au-delà de ça, donc, je retiens aussi cette fameuse technique américaine de reconnaissance de culpabilité. Oui, pourquoi pas, hein? Pourquoi pas donc rémunérer l'aveu, hein? Et donc, au lieu de rechercher les preuves, nous avons quelqu'un qui reconnaît sa faute et qu'on doit donc l'encourager par l'exonération dans certains cas, mais aussi par la réduction dans d'autres cas. Tout cela peut donc être utile pour notre expérience. J'ai vu aussi une technique très intéressante dans l'expérience espagnole qui est l'astreinte journalière. Hein? Ah oui, ça c'est très important. Hein? L'astreinte, elle est reconnue par notre droit, figurez-vous. La loi sur la sécurité sociale reconnaît pour la Caisse nationale de sécurité sociale le droit d'infliger une astreinte journalière pour les employeurs qui ne respectent pas certaines obligations de cette loi, telles que la présentation des documents comptables et de paie. Donc, pourquoi pas une astreinte journalière surtout, elle peut marcher bien avec les offres commerciales qui sont de courte durée. Donc arrêtez maintenant. Si vous n'arrêtez pas, vous serez obligé de payer chaque jour un montant pour cette infraction. Et on règle comme ça la question de procédure qui est très lourde. Rapidement, je passe la parole à une autre expérience. C'est l'expérience de notre voisin le plus proche, donc l'expérience italienne. Donc la parole à monsieur Vincenzo. Voilà.
Merci, Monsieur le Président. Je vais parler anglais car comme as you have noticed this morning, my French is horrible. I'm feeling a bit uncomfortable, I do say now, being the last speaker of the morning, and it came up a proverb an African proverb that my president used to say, which says the proverb, never stay between the rhinos, you know, the animal, and the water. And I'm feeling as being the only obstacle between you and the lunch. So I'll do my best for making it fast and simple. And you can interrupt me whenever you want to go to drink the water. Let's start. I'm not going to spend too much words on the general framework, as the Italian framework is very coherent with the European legislation and regulation, and it is inspired to the same guidelines and principle, the efficacy, the appropriateness, and the adequacy for the proportionality of the fines, and the legal certainty of the procedure. So I don't want to enter too much into detail in this aspect. However, I would like to make some consideration on the law framework. Our system is based on two different primary laws. The law 689, which is the law which regulates all the administrative sanctioning proceeding, and the electronic communication code, the Article 98, which specify the sanctioning for the electronic communication sector. So I come back to a question of this morning. Yes, we adopt principle and procedure which are very similar to the ones used when you are not respecting the red light. However, I agree with you that the red light, the infringement of the red light is very different from the infringement of a telecommunication decision. But the procedure and the relationship between the judge, in this case the AGCOM, the regulator, and the operator is very similar. Our code specifies the amount of violation very precisely for different type of violation. For the violation of which I think we are talking about, I mean the violation related to the decision of AGCOM, of the regulator, the sanction, the minimum and the maximum sanction is the range is from 120,000 euro and to 1,500,000 euro. In the case that the violation concern, the infringement concern a decision, an obligation for an SMP operator, an operator which has been notified as having significant market power, we can adopt a fine in the range between the 2 and the 5% of the overall turnover. So it's quite heavy, more heavy than yours, where you have the 3%, which is heavy, I can imagine, but you have 0 as the minimum. So in this case, we have 2%. The amount could be different. For instance, it's not written here, but in case of violation of the contract of end user, the range is between 58,000 and 580,000 of euros. So we have a modulation of sanction according to the case that we are evaluating. Further, there is another element on which I'm going to talk more precisely, more into detail afterward, that concern the possibility of introducing in the sanctioning process the commitment procedure, very well-known procedure, mutuated, translated from the competition law. As for the procedure, it's very similar. Also in this case, I would like to make some comment. We can start the procedure after a complaint received by an operator or an end user, in case of end user sanctioning procedure. We can start autonomously the procedure with a preliminary investigation. So there is a phase of preliminary investigation that should last not more than 90 days from the moment in which the infringement has been done. Within 90 days, the offices of AGCOM have to, if they are sure that there has been an infringement, they have to notify to the operator, in this case, a contestation letter which specifies exactly what has happened, the violation, the indication of the infringement. It has been violated the law number, the regulation number X.Y, Y, and so on, and the case handler, and the preliminary investigation, and also a definition of what could be the fine between a certain level, what could be the fine, up from the minimum to the maximum. Finally, the duration of the procedure. In Italy, the duration is based on a note, contestation letter, notification of the contestation. It's to 200 case, the operator that has received a notification of the contestation can do three different things. First of all, stick to the procedure. It can present, it can have access to the documents, it can present its allegation, its defensive memory, and so on, and can be also asked to be invited for an hearing. And then the procedure starts with the offices of Agicom. As if you look at the last line, there is a separation, a clear separation between the offices and the board of the authority which decides. So there is a clear separation from the procedure and the decision. So the operator can stick to the procedure, and it could present its, justify its conduct, and then wait for the final decision from the board of Agicom. It can, in some cases, not all cases, and it's not, and it's no longer true for the cases that we were discussing, the case of the decision of Agicom, it can close the procedure paying a very reduced fine, with this, an amount of 10%, if I well remember, 10% of the amount, but this possibility is no longer possible to be performed in the majority of cases. And finally, he has a third option, to start to avoid the sanctioning, proposing a sort of commitment to improve its conduct through the adoption of measures that can improve the competitive framework of the market. So there is a third possibility, wait for the decision, pay or file if the decision is positive for the operator, pay the reduced fine, or propose commitment to avoid in the future the repetition of the conduct. This is the third possibility that has been recently introduced. Recently, I mean 10 years ago. And I want to enter into detail on this possibility, just to add a new input, a new material for discussion for you in the time when you are reviewing the framework. As a matter of fact, we have considered what is been done in the competition law, the possibility of once that the competition authority is submitting an operator, an enterprise to a fine, the possibility for this enterprise to present commitment for avoid the sanctioning, but at the same time to change its attitude, its way of conduct, to modify, if you want, the regulatory situation. The presentation of engagement, of commitment, can be done only once that the operator has stopped to the infringement. Of course, you cannot say, I continue to make the infringement, but I am presenting the commitment. So you have to preliminary, you have to stop the conduct, the infringement conduct. And the engagement are presented to the NRA, the commitment are presented to the NRA, the Agicom, and the Agicom has to evaluate whether these commitments are appropriate for, let's say, improving the competition situation, and, let's say, stop in a permanent way the conduct of the operator, the conduct violating, of course, the rules that we have done. The procedure is quite complex, I do say, since the operator can present its proposition condition of commitment. If AGCOM considers this commitment appropriate, we start a sort of public consultation, not a sort, a public consultation, in order to make available to all the concerned parties this specific commitment and give the possibility to all concerned parties to propose comments, to make amendment to the commitment themselves. After the end of the consultation phase, AGCOM is evaluating the result of the consultation phase and is going to propose to the operator a modification, could propose to the operator some modification of the commitment in order to make them more, let's say, suitable for the situation, for improving the competition framework. The operator can accept this modification or can even refuse such a modification. If the operator refuses the modification, then the procedure is stopped and we start again with the original sanctioning procedure. Then once that we have, let's say, and we can also negotiate if you want, the commitment between the operator. At the end of the procedure, we have a final proposition, a final version of the commitment, and then this commitment are approved by AGCOM and are considered mandatorily. The respect of this commitment became mandatorily for the operator. In this case, AGCOM is going to hold, to suspend the sanctioning procedure just till up the verification that the commitment has been respected during the following years. Normally the commitment concerns modification that could last for 3-5 years and even more. Once that AGCOM execution, that later on to do commitment. We are going to translation exam. Our regulation, just one thing, if the commitment are not respected during the 3 or 5 years, we start again the original sanctioning. We continue the original sanctioning, but we are imposing another sanction for not having respected the commitment, as the commitment are part, if you want, are part of the regulation. Why we have done such a new way of for the sanctioning procedure? Since we realized that leveling the competition, the operator changed his behavior and he accepted a new way of working, and at the end, it's better to have an improvement of the regulatory framework rather than having just a fine paid by the operator. And by the way, the fine is not paid to AGCOM, but the fine is paid to the state budget. So we are not taking any advantage of the fine paid by the operator. Then I have a couple of examples for this. However, I can run just one example instead of taking so much time. This slide, this chart, statistics just to show you, for one side, the statistics of this on the dossier on which we have applied the sanctioning in the last years. The most of them were on number portability and migration procedure. That means not only number, but that is the number portability in the fixed sector plus the unbundling of the local loop. We call it migration procedure. The other sanctioning procedure concerned the parity of treatment. something related to the numbering plan, and the replicability of commercial offer, which is not the control of the offer that probably you in Tunisia have, but it's the replicability of the offer made by the incumbent, by the notified operator in the detail market, which has to propose offers that are over the cost, and we can check through a mechanism whether this offer can be replicable from the competitors. And these statistics to show that the most part of the sanctioning procedure that we have started in the last years were concluded with commitment rather than paying a sanction. The red is injunction, which is at the end of the day, injunction is the payment of the fine. Most part of the sanctioning procedure were concluded with commitment. So the operator found the way of commitment useful for them for avoiding the payment of fines, but also useful for us as it brought to a modification and improvement of the regulatory framework. I have two study case. I just presented just one, the first one, that concern the number portability. We have a big case of number portability near 2007 and 2008, where we realized that almost 78% of requests of number portability were blocked since the operator, the donating operator, were stopping the number portability of a client, saying that the client has changed its mind and it wants to remain on the donating network. This is nothing that is forbidden, I do say. It is forbidden, however, according to our decision, the possibility for the technical department of the operator, which receive the request of portability from the technical department of the donating operator, to issue, to create a list of clients that want to change and give such a list to the commercial department of the donating operator. In fact, our law, our decision, 2001 decision, says that the data that are concerning the client that have requested the number portability shall be treated only for, shall be used only for the for carrying out the number portability activity, and cannot be, this is the meaning, it's not explicitly written in the law, but cannot be transmitted to the commercial operator, to the commercial part division of the operator for other activities. Yes, I almost finished. We started several infringement procedures on this, as we realized, as I said before, that 70%, 80% of the requests of number portability were blocked. And that was in favor of the biggest operator, normally, since they had what they were doing. They were proposing to the client that want to have the number portability more advantageous offer, and in order to retain the client on its network. We made, I think, started 10 infringement procedures toward the 3 largest operators, and after the 10th sanctioning procedure, the operator requested to start a commitment procedure, and the commitment procedure started with the suspension of the behavior of the comportment of the operator, and then the operator proposed a commitment in which he modified its internal structure and organization in order to block the flow of information from the technical division and the commercial division. And also he forbid the commercial division to call the client when they know through illegitimate way that a client wanted to change operator. Of course, that doesn't mean that the division part cannot call the client, but of course it could be during a normal campaign, but not, it cannot call selectively only the client that has requested a number portability. So through this commitment, and then it started with one of the three operators, and then this commitment were replicated by the other two big operators. The situation was, let's say, put under a physiological condition, and we, one of the commitments was also the creation of a third party that was monitoring the effectiveness and the actual performing respect of the commitment. And through this, we have modified after 2 or 3 years from the first commitment, we have modified our rules. So in the number portability regulation, the operator is forbidden to make a retention with the operator that wants to, with the client that wants to change operator, and it is prescribed to have the number portability in 1 day, 1 working day, according to the EU rules. That means that the operator, the donating operator, he could do the win-back activity, and in 1 week a client could change operator from one side and come back after a successful win-back activity, which is not forbidden, the win-back, provided that the client has given his consensus to be called for receiving commercial proposal. So, Mr. Chairman, I have finished. Now I hope to have a bit clear. Just one thing. All the presentations that have been given this morning will be available on the website of the project that we are building up. So I think it could be useful for you to have a look on the presentation in the future. Thanks a lot.
Merci. Alors, je m'excuse auprès de tous les intervenants. J'ai donc dû serrer un peu les bousculer un peu par le temps, donc pour pouvoir terminer donc à terme. Je ne sais pas, est-ce qu'on va enchaîner avec le débat ou on passe directement au rapport de synthèse de Si Kamel Rezghi. Donc, je vous propose donc 10 minutes de questions-réponses, mais soyez, s'il vous plaît, un peu bref, et pour pouvoir donc aller directement au rapport de synthèse. Oui, merci.
Je voudrais tout d'abord remercier les intervenants pour nous avoir exposé l'expérience européenne et américaine. Je voudrais intervenir en tant qu'extérieur, en tant qu'observateur.
Alors, vous vous présentez, monsieur.
Habib Ben Abdeslam, membre permanent à l'ENT. Bien que je suis membre, mais je viens de débarquer. C'est pourquoi je dis je vais intervenir en tant qu'extérieur. En assistant aux intervenants de ce matin et aux expériences européennes et américaines, moi j'observe que la situation est similaire à plusieurs aspects, ne serait-ce que les multiples amendements au cadre juridique qui ont subi pour les uns et les autres. Mais toujours est-il que l'ambiguïté dans les textes et dans la définition de certains termes reste à débattre. Et je reviens sur l'intervention de Madame Ivna. nous proposant les directives européennes et en précisant que ces directives ont été conçues d'une façon claire, précise et sans ambiguïté. Et je reviens sur les caractères dissuasifs de la sanction. Je ne vois pas comment peut-on apprécier les caractères dissuasifs de la condition dans la mesure où nous constatons dans ces domaines et dans d'autres domaines qu'une sanction efficace à 100% n'existe pas. Et comme l'adage français dit, tout est relatif et la seule chose absolue. Je dis ça pour dire que la sanction pour l'autorité de régulation n'est pas une fin en soi. L'action de l'autorité, c'est de réguler, ce n'est pas la sanction. Mais lorsque on voit l'objectif de la sanction, c'est d'arrêter les pratiques déloyales ou illégales. Mais nous assistons dans ces domaines et dans plusieurs domaines que la pratique qui a subi la sanction se répète à plusieurs fois. Ceci parce qu'il est difficile d'apprécier les caractères dissuasifs à plusieurs titres. Tout d'abord, l'opérateur, dans les domaines de la télécommunication et dans d'autres domaines, en connaissance de la longueur des procédures et de la valeur de la sanction, il peut prendre le coût de cette sanction dans les calculs de ce coût pour le lancement d'une offre commerciale ou d'une pratique illégale. Il peut tirer profit de cette sanction. Et merci.
Alors, merci, Monsieur le Président. Voilà.
Thanks, Chairman, to give me a floor. Question for all speakers. Just a little question. IoT, Internet of Things, need for a new legal environment. It is, or is that even they need a new procedure or penalty procedure? Thanks very much.
Juste une question. Donc, ma question est la suivante, c'est-à-dire que je voudrais connaître le sentiment des intervenants qui nous rappellent du caractère dualiste du système tunisien en matière de régulation qui prévoit des sanctions administratives, des sanctions juridictionnelles. Les praticiens du domaine connaissent bien toutes les difficultés qui découlent de cette dualité. Parce que ce que j'ai bien compris à partir de toutes les expériences, c'est que le régulateur des télécoms est là pour prononcer des sanctions administratives. Souvent, de plus en plus, le régulateur est, c'est-à-dire c'est à partir de requêtes venant des consommateurs que on déclenche le processus de sanction. Donc, comment ils jugent, selon leur propre expérience nationale, ils jugent cette dualité? Parce que c'est vrai qu'en Tunisie, et cette question est très importante parce que je la conçois dans la perspective d'une future réforme du système. Est-ce qu'on va garder ce système dualiste dans lequel le régulateur parfois se comporte en tant que tribunal, ou bien on va unifier la procédure et donc dire que toutes les décisions du régulateur en matière de contrôle du respect de la réglementation ont une nature administrative, et donc voilà.
C'est clair, c'est Kamel, cher maître. Alors, oui, monsieur. Bien sûr, bien sûr.
entre 3%, la proposition de Mme Henel ce matin sur le bénéfice des offres, et 5 fois et plus autre chose lorsqu'on regarde le modèle espagnol. Donc il y a une grande différence. Donc, et en Espagne, si j'ai bien compris, que l'amende ne doit pas être inférieure au bénéfice. Ça, c'est le minimum. Hein. Donc il y a une certaine... si on va appliquer, juste pour plaisanter, donc, les meilleures pratiques internationales, je pense que ce 3% doit être révisé. Merci.
Alors, la réaction des opérateurs avant de donner la parole aux intervenants pour répondre à ces questions. Allez-y, allez, prenez la parole. Donc, voilà, Hannah.
Je peux citer aussi la pratique américaine. Ils ont parlé de la politique. On peut réduire, si j'ai bien compris, le montant de... ils appellent ça... pardon... C'est à peu près l'amende, en fait. Donc, il n'a pas mentionné, M. Kelly, les critères qui permettent à cette instance de réduire ce montant-là, mais il a évoqué cette éventualité. Donc, les pratiques sont... Il y a de ça, ça va de l'élévation vers la réduction. Donc, on peut adopter les deux cas de figure.
Et l'exonération, même, en Espagne. Alors, Tunisie Télécom, une réaction très rapide, ou bien Orange, comme vous voulez, si vous êtes prêts pour ça. Bon, d'accord, elle est pour la baisse. Alors, je passe rapidement maintenant la parole à Mme Ivan pour répondre surtout à la question du caractère, tout d'abord, du CASIF, mais aussi de son avis sur la dualité du système tunisien.
Oui, bon, en général, je suis assez d'accord avec votre opinion. Sur la notion de sanctions dissuasives, on devrait faire des exemples, je crois. Parce que oui, c'est vrai que le cadre européen est clair, parce que le mot est clair, mais j'aimerais prendre comme exemple votre article 74. Pour moi, une sanction dissuasive est une sanction qui pour soi-même est capable et suffisamment claire à empêcher, à convaincre l'entreprise à retirer, à effacer son comportement. Bon, si nous avons un système qui prévoit d'abord une mise en demeure, qui ne prévoit pas un délai de temps certain entre lesquels on peut dire que la conduite est réellement cessée ou continue. Et puis il y a la possibilité d'une injonction qui n'est pas jamais, si j'ai bien compris votre système, ensemble amené par une pénalité financière. Et si nous n'avons pas un système qui, dans le même temps, fait comprendre à l'opérateur qu'il y a, comment dirais-je, qu'il y a une vitesse dans la réponse, donc parce que je crois que ce système actuel n'est pas doté de vitesse dans la réponse. Il laisse trop de temps. Et donc les bénéfices pour l'opérateur peut s'augmenter dans ce délai. Donc, en général, je ne sais pas si je suis été claire, mais on devrait voir en concret. Probablement, il faut en parler en analysant les conduites, les comportements des opérateurs, les pratiques illégales. Je voudrais plutôt me concentrer sur l'autre question, sur l'efficace d'un système dual de sanctions. Et en particulier, si le sujet qui règle est le sujet juste à sanctionner qui sont contraires aux règles qu'il a posées. Je me suis interrogée plusieurs fois, même pour l'expérience italienne. Parce que, par exemple, nous avons l'autorité pour la concurrence qui est une autorité très forte, très vite dans les réactions et qui souvent tend à sanctionner les conduites illégitimes des opérateurs dans le domaine des communications électroniques. Bon, je crois que notre expérience nous a enseigné que le degré d'expertise qui a acquis le régulateur, c'est-à-dire AGCOM, est notamment et forcément supérieur du degré d'expérience et de compétence qui a l'autorité qui normalement s'occupe de sanctionner des conduites en les voyant ex post, c'est-à-dire après la violation et pas ex ante, avant que la violation soit perpétuée. Je ne sais pas. C'est clair. Et bon, je ne sais pas. Le président parlait et même l'autorité espagnole parlait d'un système tout à fait péculier, d'une sanction déterminée d'un montant pareil au bénéfice que l'opérateur a obtenu. Je crois que c'est très important, politiquement très intéressant, mais je crois que c'est difficile à déterminer, à quantifier une sanction pareille dans le cas concret.
D'accord, merci. Alors, je passe la parole maintenant à M. Cameroun. Alors, on ajoute la question de M. Houssine. Sur, y a-t-il des sanctions qui ont été donc infligées à un opérateur concernant l'activité de l'Internet des objets, hein, n'est-ce pas? Oui, voilà. Est-ce qu'il y a des sanctions qui ont été donc infligées à un opérateur concernant ce domaine d'activité, ce service?
There have been no sanctions involving the Internet of Things in the United States, largely because it is not really regulated. We have spectrum that's available to be used on a low power shared use basis, which prevents one operator from interfering with anyone else, and therefore there's no real concern about any sort of infringement of anything. There are no licenses, and there are some technical standards that apply to different equipment. segment of the
No, no, in general.
In general, yeah. Because we were talking about many interesting things. About Internet of Things, I have the same comment. We haven't had any, us or the ministry impose a sanction on this subject because it's not particularly regulated. About the limits of the sanctions, or the Spanish regulation, the telecommunications, the Spanish regulation specifies that the sanction for very serious infringements can range until 5 times the gross profit obtained by the commission of the infringement. As I said before, it's quite difficult to calculate that gross benefit because sometimes, for example, the infringement is the use of a specific number for services, activities that are not allocated to those numbers. And for example, we had carried over an inspection, and we have the evidence of 2 or 3 calls, but we have some kind of evidence that the conduct is affecting more calls, for example, but we don't know exactly the benefit many times. Or so we have estimations. So we are already cautious with this rule, and we look at the financial state of the company, also, which carry us to the, for example, to the benefit of the company for the activity itself, not coming from the infringement. You know what I mean? So we use the 2 parameters. The other specific thing that we were talking about as a minimum is very interesting to mention. It's not that our telecommunications law says that minimum for sanctions. We don't have a minimum. We have a general principle in administrative law that says that infringement, the commitment of an infringement, I translate more or less, cannot be more profitable for the infringer, for the legal person, than the sanction itself. So if we get to a conclusion that if we know the benefit, it has to be following this principle. The sanction has to be higher, because if not, we get to that conclusion that it would be more profitable for companies to non-comply than complying. You know what I mean? It's like it's a logic. It's not in the telecommunications laws. It's in all our punishment system. And another thing that I wanted to mention is that all these principles are in our administrative laws. We don't go to penal or to criminal laws anymore. I mean, we have the criminal principles or criminal laws as a source to complete certain things, but the majority of the principles are in the administrative laws, and we don't have this problem with the duality between administrative and criminal activities, because what we do is to impose administrative sanctions that go to the administrative court later on and to the Supreme Court. And the criminal offenses are regulated in other code, the criminal code, and we don't have anything to do with that. So we don't have that issue. I don't know if I'm leaving something.
Thank you. Donc, très intéressante. Bon, on finit par Monsieur De Bianco pour réagir à ces différentes questions. Donc, présent.
Yes, thank you. I'm always the last one. And this time you are really angry, I guess. No, just one thing. I think I am the only engineer at this table. So I was interested from the question concerning the Internet of Things. And I am fully agree with what Mr. Cameron says about the needs not to regulate what is commonly used without any license or authorization. I want to add that before thinking of establishing a specific sanctioning system for the Internet of Things, it is necessary to clean up the regulatory and authorization, the regulatory framework with particular regard to the license and authorization scheme. I think that you should clarify, since the problem, we have the same problem also in Europe, even if maybe less heavy, it's lighter. We need to evaluate who is doing what in the Internet of Things, the business model, which part of the business model is subject to a license, to an authorization, and which part is not subject to any license and any authorization. And if I may give an advice, not over-regulate anything of this sector, since the over-regulation could block the development of this interesting sector that is really one of the key sectors for the future development of the digital economy. That's all.
Merci, monsieur. Merci, monsieur Lobianco. Nous arrivons ainsi donc à la fin de notre session. J'invite monsieur Maître Kamel Rezghi donc de nous donner le rapport de synthèse. Allez, venez. Oui, allez-y. Vous allez prendre ma place, Kamel. Allez-y. Non, vous restez. No problem.
Tu es le président de la séance.
Allez-y, vous allez clôturer.
Ok. Donc, puisque c'est le temps de déjeuner, je vais faire rapidement. Donc, dans le rapport de synthèse, je ne vais pas, en réalité, répéter ce qui a été le résumé de toutes les interventions. Je vais être plutôt concret et mettre en évidence les points focaux qui ont été discutés d'abord et tracer les pistes d'amélioration de la réglementation tunisienne, donc relative à la sanction donc, prononcée par le régulateur des télécommunications. Donc, toute la matinée, nous avons vu que le thème du séminaire donc, tombe à point nommé par rapport à l'évolution actuelle aussi bien du secteur des télécommunications que l'évolution des modes de régulation qui sont mis en œuvre par l'INT, donc surtout dans des marchés de plus en plus concurrentiels en Tunisie. Donc, ce thème met en lice divers enjeux, tenant à divers impératifs. Premier impératif, donc, tenant à l'effectivité de l'action du régulateur. À mon sens, bien que le rôle du régulateur des télécoms ne se limite pas uniquement à prononcer des sanctions. Il n'est pas un tribunal, il a toute une batterie de mécanismes de régulation qu'il peut mettre en lice, mais bien sûr, selon l'expérience tunisienne, c'est mon avis personnel, l'INT, en quelque sorte, n'a lorsqu'il fait, bien sûr, tout en utilisant les autres modes de régulation que nous connaissons. Donc, c'est ce qui a occasionné, surtout chez les opérateurs de réseau essentiellement, des attitudes parfois négatives en contestant la légitimité de ce pouvoir. Et nous avons vu aujourd'hui qu'il reste des voix qui contestent encore la légitimité de la sanction en tant que modalité de régulation. La réaction était aussi par donc le recours à entre guillemets à un bombardement ou un noyautage du régulateur de recours devant le tribunal administratif ou bien devant la cour d'appel, etc. Donc, ce qui montre que vraiment, lorsque le régulateur a fait montre de l'exercice de son pouvoir de sanction, il a en quelque sorte dérangé. Et je pense que l'organisation de ce séminaire vient dans ce sens-là. Donc il s'est repositionné en quelque sorte. ce thème met en lice aussi des enjeux d'ordre économique qui ont été précisés par les intervenants, des enjeux tenant à la concurrence, des enjeux tenant à la protection du consommateur, des enjeux économiques même pour les opérateurs qui sont en train de payer des amendes plus ou moins importantes, etc. Et aussi des enjeux juridiques. La plupart des intervenants ont mis en évidence un certain nombre de principes juridiques, tels que le principe de la légalité de l'infraction et de la peine, même administrative, le principe de proportionnalité entre l'infraction et la sanction, les principes de droit de défense, le principe contradictoire. Donc ce sont des enjeux juridiques qui n'ont pas manqué d'exister dans nos débats. Ce qui a fait que ce séminaire a été divisé en 2 temps. Donc une première séance consacrée au bilan critique de la réglementation actuelle, du Code des télécoms en général, mais en particulier l'article 74 du Code, et aux expériences comparées. Donc pour être concret, moi je vais dans un premier temps mettre en évidence les principaux points focaux qui ont fait débat aujourd'hui, pour voir dans un second temps quelles sont les pistes d'amélioration de la réglementation, bien sûr tout en m'inspirant des différentes expériences comparées qui ont été présentées. Donc quels sont c'est-à-dire la rédaction du Code des télécommunications à travers toutes les évolutions qu'il a connues, et à la lumière de la pratique, a montré des faiblesses sur un certain nombre de points que je vais schématiquement, parce que c'est un rapport de synthèse. Premièrement, la dualité justement de la sanction, de la nature de la sanction. Est-ce que c'est une sanction administrative ou une sanction d'ordre juridictionnel? Des limites tenant à la définition de la nature juridique de la mise en demeure et de l'injonction. Est-ce qu'elle fait partie des décisions administratives, ou bien est-ce qu'il s'agit de sanctions, ou bien des mesures de préparation de la sanction? Un problème juridique s'est posé. La définition du principe de la proportionnalité de la peine, dit autrement le principe de la dégradation de la peine. Est-ce que l'article 74 établit ce système de dégradation ou non? Quels sont les critères de dégradation de la peine? Les critères de l'efficacité de la sanction. Quand est-ce qu'on peut dire qu'une sanction est efficace ou non, surtout qu'on est dans un domaine qui est mouvant, où le régulateur n'est pas une simple autorité de contrôle, il doit agir vite, etc. Les types de recours que pourrait toucher une sanction, que ce soit les recours contre au fond ou bien les recours dans le cadre d'une procédure de référé. Donc, est-ce que c'est le recours pour excès de pouvoir ou bien l'appel, etc. La détermination des infractions dans les détails, c'est-à-dire c'est un grand problème qui met en œuvre un grand principe du droit administratif et même du droit en général, droit pénal, c'est le principe de la légalité des infractions et des peines. Donc nous avons vu, les opérateurs ont insisté sur ça en disant que vraiment le régulateur a un pouvoir discrétionnaire très large en matière de définition des infractions. Il y a un manque, il y a des critères flous quant à la fixation du montant de l'amende prononcée. Il n'y a pas de critères. Le texte ne dit rien sur les critères de fixation de l'amende, etc. On a aussi évoqué des problèmes relatifs à la procédure de l'autorité liée à la sanction, bien sûr, dans la pratique. Voilà. On a aussi remis en cause les garanties d'un procès équitable, un procès entre guillemets équitable, donc les droits de défense, les procédures contradictoires qui n'ont pas été explicités dans les dispositions de l'article 74 du Code des télécommunications. Donc, voilà les problèmes qui ont été donc, vraiment mis en évidence dans nos débats. Et à la lumière des échanges que nous avons eus, des débats, et à la lumière des expériences étrangères, donc la réglementation européenne, la réglementation ou bien l'expérience du régulateur italien, l'expérience du régulateur du régulateur espagnol. Donc, un certain nombre de pistes d'amélioration semblent se dessiner et peut-être, je propose peut-être au président de l'instance que l'issue ou l'output de notre séminaire prenne la forme de recommandations, donc qui peuvent servir dans les travaux qui sont en cours actuellement en matière d'élaboration du code du numérique, tout en essayant au maximum pour faire adopter ces nouvelles orientations en faisant recours à des consultations publiques selon la démarche participative qui a été défendue ou bien qui a été présentée par le président de l'instance. Donc l'idée justement c'est dans le cadre du nouveau code numérique, il faut que toutes ces questions-là soient clarifiées, justement en se basant sur les expériences étrangères qui ont été présentées dans notre séance. Voilà, j'ai voulu faire court et ne pas entrer dans les détails. Et je vous remercie.
Je voulais juste remercier nos conférenciers, Monsieur quand même, c'est pas grave, tout le monde nous donner leur point de vue d'une façon claire, je pense, et leur point de vue sur le code existant et les différentes problématiques qui existent dans notre actuel code, et on espère améliorer, apporter toutes les modifications nécessaires pour rendre le code assez transparent, lisible, avec une seule lecture. Voilà. Donc je remercie tout le monde et à la prochaine, Inch'Allah. Merci.